My interview of John Tehranian is real video I filmed of myself and the interviewee in the creation of this program. Other video shots of me I created from a script I wrote using a generative artificial intelligence AI platform and my own avatar of me. We hope you enjoy reality and AI merging in this video. Is copyright law racist? Is it sexist? We will explore this today through our interview with the author of a fascinating book on copyright called The Secret Life of Copyright. Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program looks at our copyright laws through the prism of a fun and fascinating interview with a different approach to unpackaging the way copyright law works. We ask, do our copyright laws have some implicit sex or race bias issues in them at work? And if so, how do we fix it? We will thus look at a variety of copyright issues then, through this lens, and do a dive into these questions that surround our intellectual property laws, looking at each side of the issue. And before we look at our agenda, let's start with a quick part of the interview to understand why this book now, and how is copyright operating poorly from a race and gender lens.
John, can you tell us why today and why this book and the story of this book and copyright law is particularly important for our legal profession in general, for the generalists who are watching, but also for intellectual property lawyers and copyright lawyers in particular?
There are a few reasons for that. I think one reason is, we're at a stage where over the last few years, we've been questioning some of our existing social structures and asking, okay, are there certain embedded inequalities in these social structures? And so my kind of rubric for analysis is saying, let's take a look at one specific social structure, the legal system, and in particular, how copyright law applies, and look at it with respect to how it operates on, like I said, traditionally kind of marginalized communities, how it impacts race, how it touches on gender, how it impacts socioeconomic status. So I think that's one thing as we're kind of thinking about these issues in a more holistic way socially. I think the other really important point is, this is probably going to come to a surprise, no surprise to anyone who's watching this video, is we've entered the age of AI for many of us quite suddenly. AI is literally beginning to, enmesh itself into every aspect of our daily life. And one of the most important questions regarding AI is the copyrightability issues related to AI. And this is on several axes. I mean, first, there are the large language training models, which are training on the world's content. And the question the courts have had to grapple with and going to have to grapple with is whether this is infringing or whether this is fair use. But also there are questions as to whether AI output is infringing, whether if I ask AI to write a song in the style of the Beatles, that may infringe the Beatles copyrights, or if I want a George Lucas-like movie for AI to make for me, if that infringes the rights of George Lucas or, a director like Quentin Tarantino. And then finally, there's a question as to whether even the AI output, even if it is original, is copyrightable itself. There's litigation percolating that suggests that AI is the product of a machine, and because machines are non-human, based on the existing standards that the Copyright Office has promulgated, as well as prior case law involving a very famous case involving a monkey taking a selfie of himself, which was deemed uncopyrightable. The idea is, so far, AI has been said to not be copyrightable, and there are many people who question that, whether there is sufficient input, from prompters in terms of selection and arrangement of works as well. All of these issues are copyright issues. All of these issues are going to basically tell us how the world is going to operate, who's going to have rights over AI content. And so how these issues are decided doesn't just have tremendous economic impact, but also has tremendous cultural and social impact. And analyzing this through the lens of egalitarian as well as efficiency interests, I think is particularly timing at this juncture where we're in the advent of the.
All right, the big $64,000 question. Is copyright law fundamentally operating in a manner that could be potentially deemed racist and sexist?
So that's a great question, and it's a natural question, kind of, that my book is driving at. It's called The Secret Life of Copyright. It talks about race, gender, and socioeconomic status, and kind of calls out some aspects of copyright law doctrine. But I think it's important to take a step back. I'm not saying there's anything intentional in the design of copyright that is racist or sexist or, classist. What I am arguing, though, is that the structural features of copyright law, whether wittingly or unwittingly, have systematically disadvantaged and disproportionately minorities, women, and individuals who are from poorer backgrounds in terms of the protection and the enforcement of their rights. And the argument I make is that's not just bad from an egalitarian point of view. It's also bad for our copyright regime because a lot of these people are creating and providing important input into the progress of the arts, the overall kind of point of the copyright system as embodied in the US Constitution, which talks about progress in the arts and copyright. And so my problem is not just the egalitarian issue, it's that this systematic, unwitting disadvantaging of people on the basis of race, gender, and class is actually is not allowing us to properly recognize creativity in lots of modalities, and therefore impoverishing our copyright system and its efficacy.
Those snippets are fascinating, and let us dive now into our issues. So let's cover our agenda and where we are going today. We will get a substantive copyright law overview of the key precepts of copyright law. This includes authorship, who is an author and who is not. We will look at co-authorship and the intent rule. We will address originality and fixation. We will look at derivative works and the scope of derivative rights. We will look at fair use and see a fun rock and roll case involving Green Day. And we will do all this by also looking at an interview on the secret life of copyright and race and sex-based issues in copyright law with the author. This gives us a chance to look at a series of fascinating cases. We look at a case where Hitler sues in America's federal courts, yes, believe it or not, it happened, and a case where Harvard claims copyright ownership of a Civil War photograph of a female slave. We will look at a case of the ESPN broadcaster who was a victim of illegal nude videos taken of her without her consent, and how she can't get videos of her taken down given copyright law precepts. And we will explore the case of the man who killed himself with a detailed suicide note online, one his wife did not like, and how copyright law allowed her to take it down. Ultimately, we learn copyright law fundamentals and see where copyright law works and arguably does not work. And we see with our author interview some proposals for reform. Where does copyright even come from? The Constitution, it turns out. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This language is the basis for United States copyright law and also our patent law. Let's start at the highest level. What types of works fall within the realm of copyright? Copyright protects books and other writings, music, movies, and films, photographs, artwork, software, and source code, even architectural works and clothing, designs, as well as pantomimes, choreographs, and plays. This is just an illustrative list and is not exhaustive. What it does not protect is ideas, and the line between ideas and expression is very important in copyright law. Copyright law protects a given expression, but not the underlying idea. In other words, when Einstein developed his special theory of relativity, the paper he wrote would be copyright protected. But the idea of E equals mc squared, or the idea of special relativity, would not be protected. Other people can write and discuss that theory. The question would be whether, in so writing, they actually copied his expression of that underlying set of ideas, or if they wrote their own original expression. This idea expression line is a critical fault line in copyright, and courts will inquire as to whether the work at issue is really expression or just an idea. This is because under the Copyright Code, specifically Section 102B, no, quote, idea, procedure, process, system, method of operation, concept, principle, or discovery, end quote, is subject to copyright protection. In other words, copyright law is not going to allow one to monopolize ideas, systems, or other discoveries. The idea sounds simple in articulation, but often in practice it can be very thorny. Here is a great quick example of the line from a Ninth Circuit case involving a yoga practice. A plaintiff, Bikram Yoga, claimed a copyright in a series of 26 yoga steps and poses performed during the yoga workout. A defendant used the same or a very similar set of the 26 steps in their yoga studio called Evolution Yoga, offering hot yoga. Plaintiff was unhappy and sued, claiming copyright infringement. The Ninth Circuit held that the 26-step sequence described in plaintiff's book was not protectable against others using and teaching it because it was a health-based sequence and process. And, at root, it failed the idea expression line because it was an idea that cannot find copyright protection. In other words, the yoga sequence was the idea at issue, not the expression of an idea. This is an excellent and important case to illuminate the line between idea and expression that we have discussed. If you want to read the full case, which is fun and excellent for an overview of these issues, you can find it from the Ninth Circuit in 2015, case number 13-55763. Let's start in the beginning, at least the post-Constitution beginning. We've seen what things copyright adheres in. Now let's see how and why it happens. Copyright protects original works of expression that are fixed in a tangible medium. Those are dual requirements for copyright to then attach to the creative work. Let's take the very first requirement, known as originality. It simply means that the creation is original to the author. This is not a requirement of something that is new and novel and never before seen. It simply means that it is the original creation of the author at issue. The bar for originality is very low. It essentially means that there must be the most minimal creativity and copyright will attach. For example, if you are watching this and doodling a pretty cool doodle on a piece of paper, you are creating a copyrighted work in this moment. Why? Because it is an original work of expression made by you, and it is also being fixed in a tangible medium, specifically the pen to paper. But before we get to the fixation requirement, let's talk a little bit more about how courts approach the originality requirement. Courts generally do not want to get involved in making any kind of artistic determination about the artistic merit of a creative work. This is a long-standing policy in copyright law, which goes back over a century to the Supreme Court. It is indeed a fundamental bedrock principle of copyright law today. The rationale for this rule was expressed long ago by the Supreme Court, when it indicated that courts will not wade into artistic determinations because they are not equipped, and will on one end deny protection to things that are artistic, and on the other end give protection to things that may not be sufficient. This is what Justice Holmes said at the turn of the last century in the early 1900s. Quote, "At the one extreme, some works of genius would be sure to miss appreciation. Their very novelty would make them repulsive until the public had learned the new language in which their author spoke. It may be more than doubted, for instance, whether the etchings of Goya or the paintings of Manet would have been sure of protection when seen for the first time. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge. Yet if they command the interest of any public, they have a commercial value. It would be bold to say that they have not an aesthetic and educational value, and the taste of any public is not to be treated with contempt." End quote. Another underlying theme is that when it comes to creative works, very few things in the most abstract sense are truly new. Here's another quote from Justice Story. Quote, "In truth, in literature, in science, and in art, there are and can be few, if any, things which, in an abstract sense, are strictly new and original throughout. Every book in literature, science, and art borrows and must necessarily borrow, and use much which was well known and used before." End quote. These are two fundamental pole stars that frame the originality inquiry. So yes, your doodle is being protected right now. This brings us back to the fixation requirement. The Copyright Code's language is that it must be fixed in a tangible medium, which is legal language that means it must be recorded in some permanent fashion. This means pen to paper, oil on canvas, typing on a keyboard into the memory of the computer, or molding a piece of clay into a sculpture. What it also means is that if you come up with a fantastic little love poem and hire one of those sky-riding airplanes to put it in smoke in the air for your loved one, you have not fixed it any permanent form, at least in that fashion. So you now have a copyright, but what does that mean exactly? What are the exclusive set of rights you have? This is answered by federal copyright law again. And as a side note, federal law is the exclusive depository of laws that relate to copyrights, and it preempts state laws in this area. So let's look at the exclusive rights that you as a creator or author have under federal copyright law. There are several specific ones you see listed here as the exclusive rights to do and to authorize any of the following. 1. To reproduce the copyrighted work in copies or phonorecords. In simple terms, this means to make copies of something, such as photocopying or cutting and pasting or downloading. 2. To prepare derivative works based upon the copyrighted work. In simple terms, this means to make new works from the original. Think the James Bond novels, or when George Lucas made Star Wars, he had the right to make sequels, prequels, and other works based on Star Wars. 3. To distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. 4. In the case of literary, musical, dramatic, and choreographic works, pantomimes and motion pictures and other audiovisual works, to perform the copyrighted work publicly. 5. In the case of literary, musical, dramatic, and choreographic works, pantomimes and pictorial, graphic, or sculptural works, including the individual images of a motion picture or other audiovisual work, to display the copyrighted work publicly. 6. In the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. These are the codified exclusive rights. What happens, however, if the exclusive rights are tripped? This is what is called copyright infringement. To assess whether there is copyright infringement, courts employ a two-part test known as the substantial similarity test. It varies slightly by circuit, but here is the Ninth Circuit's formulation. As the Ninth Circuit held in Antonick v. Electronic Arts at 841 F. 3rd 1062 from 2016, the court employs a two-part test for determining whether one work is substantially similar to another. Specifically, a plaintiff must prove both substantial similarity under the extrinsic test and substantial similarity under the intrinsic test. The extrinsic test is an objective comparison of specific expressive elements. The intrinsic test is a subjective comparison that focuses on whether the ordinary, reasonable audience would find the works substantially similar in the total concept and feel of the works. Now, the extrinsic test is one of law for the court, so is often adjudicated on a motion to dismiss or summary judgment motion. If a plaintiff survives that gauntlet, then the jury will decide it as well as the intrinsic test. Within the intrinsic and extrinsic tests, the court must be careful to address the idea and expression dichotomy we discussed earlier. The court must instruct the jury as to 1, the non-protectable elements of the plaintiff's work, and 2, the appropriate standards such as are they virtually identical or substantially similar, and 3, that the jury may consider the work as a whole. That is black-letter law. If you want a good case on this, check out Apple Computers versus Microsoft Corporation reported at 35 F. 3rd 1435 from 1994 in the Ninth Circuit. This is an overview then of copyright law. So now we need to discuss who is the author of that original work that is fixed in a tangible medium. The Federal Code does not define authors explicitly. It does discuss a joint work as follows. A joint work is a work prepared by 2 or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. This is the only place in Section 101 of Copyright Act where author appears, but without a definition. And Section 201 mandates that, by default, copyright ownership vests in the author, but the Supreme Court has defined what exactly an author is and the contours of authorship, and this sets the stage for some of our interview's ideas on where copyright law is not working. And before we dive into that case, let's go back to our interview to understand this area of law.
So let's double click on that a little bit. One of the examples in your book, which I thought was just fantastic, is an example you give of authorial rights that vest in the person who actually snaps the photo or installs the camera. And because they are the author, we get these bad results that flow in some fascinating case examples you gave, where the person who was unfairly filmed or exploited even post-filming is out of luck from a copyright perspective in terms of protecting themselves. So, explain a little bit at that issue, and then what ultimately is the solution you propose that we as lawyers can litigate or ask Congress to fix in terms of correcting copyright law that to address this egalitarian issue?
Yeah, so one of my chapters deals with what I call the authorship as fixation doctrine. This is a doctrine that courts have come upon in large part because of convenience, and at part because, as I argue, of a misreading of an old case from the late 1800s before the Supreme Court involving the very first case involving copyright photography copyrights, a case involving Oscar Wilde. Courts basically say that it is the person who fixes a work in a tangible medium generally who is deemed the author. This helps us in terms of knowing who a copyright vests in and therefore who gets the very powerful exclusive rights of copyright. But as you alluded to, it creates some problems that don't account for creativity by people who are non-fixers. So the example I give in the chapter is people who are subjects, people in front of the camera. They provide all types of creativity input, whether it's their performance, if it's in an audiovisual work or in a photograph, the way they pose, the way they dress, other types of creative input they may put in. And yet, systematically, our system of copyright gives the rights to the person behind the camera. Now, you may ask, okay, well, that may not recognize the creativity of people in front of the camera, but what does that have to do with equality? And the answer is this: historically, the tools of production were very expensive. Having a printing press was something that only very, very rich people had. Historically, people who had recording equipment to be able to go to record old Delta blues musicians tended to be very wealthy. Cameras were expensive. Of course, that's not true today, but when we're dealing with residual content that is still under copyright protection, there was a huge disparity between who was in front of the camera and who was behind the camera in terms of race, gender, and class. And so two examples that I give in the book. One is in the 1850s, Harvard University's professor of anthropology, Louis Agassiz, sent an individual named Zealy, a photographer, to go and take photographs of individuals who were enslaved on a southern plantation. Zealy did and took these photographs and produced them, and Harvard has held them in their archives ever since. One of the photographs involves an enslaved man named Renty Taylor and his daughter Delia. And Harvard, since the 1850s, has actually been commercially licensing this photograph and making money on it, and also claiming it's still under copyright protection, which is a very interesting question. I won't digress into it, but bizarrely, they might have a claim that it still is under copyright.
Wait, but maybe pause and tell us, because this photo's 150 years old. How could it possibly be subject to Harvard's copyright?
They claimed it was not published until after 1978, and there is an exemption for works that were never published before 1978 that gives them copyright protection for another couple of decades. It's a remarkable, very odd thing. So what happened was a woman in Massachusetts learned that this was in fact her great-great-great-grandfather. And she was deeply tormented and upset about the fact that Harvard University was continuing to profiteer from these photographs that were forcibly taken of slavery. In a sense, Harvard was continuing to profiteer from a crime against humanity. She brought a lawsuit, and a large part of her lawsuit was immediately dismissed. And it was because at the end of the day, Renty Taylor, as the person in front of the camera, literally has no rights. The copyright belongs to the photographer, which then ultimately vested in Harvard University. And so she was out of luck. And so Harvard gets to continue to exploit this photograph and exploit this effective crime against humanity because of the copyright as fixation doctrine. And there is, unmistakably a huge race and class component to this exploitation.
So now that case that John spoke of, also known as the Oscar Wilde case. Here are our facts. A pose shot of Oscar Wilde was taken by Napoleon Sarony. You can see the photo there on your screen. And in turn, it was litigated as to whether the photograph involved sufficient human originality to constitute a work of authorship. That is, was the cameraman doing enough, or was it just a device snapping a photo and thus not authored by anyone human, really? And the court held, yes, as to that then new technology of photography. And it also defined an author as he to whom anything owes its origin, originator, maker. The result is that the one behind the camera who took the photo was the author, not Oscar Wilde, the subject of the photo. This remains the core judicial definition. In 1989, in a work-for-hire case, the Supreme Court again addressed this. It clarified that the author is the person who actually creates the work, that is, the one who translates an idea into a tangible, expressive form, unless it's a work made for hire, in which case the employer is the author by statute. Further, as a general rule, the author is the party who actually creates the work, that is, the person who translates an idea into a fixed, tangible expression entitled to copyright protection. So the bottom line today is this principle. An author is the human being who actually creates the expression fixed in a tangible medium of expression, unless the work qualifies as a work made for hire. Back to our interview now to discuss fixes to this rule and some other situations that have arisen testing this copyright rule.
Sorry.
No, I was going to say, what is a possible fix then within copyright law that we could adopt to address it? I mean, I guess part of it could be what you alluded to in terms of exploiting this weird rule about publication and whatnot. But that is a technicality. It seems like we need a more fundamental substantive rule that recognizes, maybe in this day and age, people on either side of the camera should have equal rights or something. I don't know. I mean, what is the reform that you think we could do?
Yeah, I mean, look, in many instances, this issue doesn't come up because usually people have contracts in place, and that's all well and good. But in the instances I'm giving you, there was obviously not a contract put in place with Renty Taylor. And in other instances, there aren't. And so my argument would be, arguably, we begin to recognize copyright interests in individuals who give significant creative components to a work. Alternatively, you could do something akin to what the studios have done with actors and actresses with the guilds in negotiating residuals that flow to people on camera, even though they weren't copyright holders, when works are continued to be exploited. So for example, every time Seinfeld is played, every time Friends is played, those casts get money, even though they weren't copyright holders, because of guild agreements that have given them economic rights. One other way we could address this, and let me just give you the other example I was going to give. I was going to give a gender example that's kind of more modern of this problem. There's a huge problem with revenge porn. This is something that's happened really over the last decade as there's been an increase of user-generated pornography online. Many people have been putting up intimate videos that are captured. Usually, not always, of course, the intimate video features a woman. Usually, but not always, the person behind the camera is a man. And what happens when this intimate footage leaks is the victim, the woman, usually, again, not always, will try to get this work taken down. But because she's not the copyright holder, because she only appears on camera, and in fact, the man who maybe in some cases unlawfully recorded her without permission, he owns the copyright. And a really sad example of this came to a head a few years ago when a stalker stalked sportcaster Erin Andrews. He followed her to a Marriott in Nashville where she was staying, found out the room she was staying in, got the room next to her, drilled a hole into the bathroom and recorded her undressing, and then leaked the footage online. This resulted in a massive lawsuit that Erin Andrews filed both against him and against Marriott. She ended up getting a huge recovery, but what she was not able to do is the tragic part. She was not able to remove the image and the video from the online environment because at the end of the day, this guy who engaged in an illegal act of trespass and recorded her was the copyright holder because he's the fixer. And this is an example of some of the tragic results and also the very unfair gender dynamic that's at play with this authorship as fixation rule. So in that situation, perhaps the copyright should have gone to her so that she, in fact, would be able to control its dissemination and indeed get it taken down.
Let's double click on this a bit more. In 2014, there was a controversy involving Cindy Lee Garcia's role in the movie The Innocence of Muslims. This involved a suit by actress Cindy Lee Garcia to enjoin Google from continuing to make the movie Innocence of Muslims available on YouTube. Garcia thought her role being filmed was for a light Arabian adventure film, and it ended up being a film indicting Islam. She was unhappy at how she was portrayed as the film incited backlash against her, including death threats, and so she sued. Garcia tried to get Google to take the film down, but it refused. So the initial opinion by Judge Alex Kaczynski of the Ninth Circuit recognized Garcia's authorial interests in her performance, which, as a creative work of authorship fixed in a tangible medium, met threshold copyright requirements. Furthermore, Garcia had not granted the filmmakers license to use her performance in the manner embodied in the final cut. As a result, to Kaczynski, Innocence of Muslims infringed Garcia's copyright interests, and she had the right to enjoin further distribution of the versions featuring her. Let's look at his opinion more deeply now. First, the court held, Garcia doesn't claim a copyright interest in Innocence of Muslims itself. Far from it. Instead, she claims that her performance within the film is independently copyrightable, and that she retained an interest in that copyright. Second, he stated, Garcia argues that she never intended her performance to be part of a joint work, and under our precedent, she doesn't qualify as a joint author. But just because Garcia isn't a joint author of Innocence of Muslims doesn't mean she doesn't have a copyright interest in her own performance within the film. Whether an individual who makes an independently copyrightable contribution to a joint work can retain a copyright interest in that contribution is a rarely litigated question. Thus, Google argues that Garcia didn't make a protectable contribution to the film because Youssef wrote the dialogue she spoke, managed all aspects of the production, and later dubbed over a portion of her scene. But an actor does far more than speak words on a page. He must live his part inwardly, and then give to his experience an external embodiment. So the Ninth Circuit held, an actor's performance, when fixed, is copyrightable if it evinces some minimal degree of creativity, no matter how crude, humble, or obvious it might be. Victory for Miss Garcia? Hold on. The en banc court reversed outright. It held, the Copyright Office found that Garcia's performance was not a copyrightable work when it rejected her copyright application. The Copyright Office explained that its long-standing practices do not allow a copyright claim by an individual actor or actress in his or her performance contained within a motion picture. Thus, for copyright registration purposes, a motion picture is a single integrated work. Assuming Miss Garcia's contribution was limited to her acting performance, we cannot register her performance apart from the motion picture. Garcia's theory of copyright law would result in the legal morass. Simply put, as Google claimed, it makes Swiss cheese of copyrights. In the Lord of the Rings trilogy, 20,000 extras tramped around Middle-earth alongside Frodo Baggins, played by Elijah Wood. Treating every acting performance as an independent work would not only be a logistical and financial nightmare, it would turn cast of thousands into a new mantra, copyright of thousands. And so the short-lived life of an actor in front of the camera being an author was brought to an end. Let's do a quick fun sidebar that takes us to Indonesia. So we learned that the one behind the camera controls, but what if that one is a monkey? And there you see Naruto, a macaw money from Indonesia. He took that photo you see there as a selfie with the camera of Slater, a cameraman who left his camera unattended. Slater published the photo and claimed copyright. PETA sued on behalf of Naruto, saying Naruto was the author. The Ninth Circuit held that a monkey selfie could not belong to the monkey as the author, because an author must be human under the Copyright Act, and PETA owed attorney's fees to Slater. The implications of the case for AI and copyright as to authorship on AI-based content is obviously significant going forward in that area. How do we have co-authors who share a work? When is one a co-author versus just a contributor that does not own? We saw some of this in the Google Garcia case we just looked at, but now we need to dive deeper. Recall the code's definition. A joint work is a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. And author is the one to whom the work owes its creation. So this is the specific case law question over interpretation for jointly created works. Is it an intent to be co-authors or an intent to co-create by merging contributions together to make a new whole? The latter is easier. The former a higher showing to get oneself into co-authorship status. Let's see how this plays out with the Spike Lee movie, Malcolm X. Here are the facts of this cited case. Warner Brothers contracted with Spike Lee and his production companies to make the movie Malcolm X, to be based on the book, The Autobiography of Malcolm X. Lee co-wrote the screenplay, directed and co-produced the movie, which starred Denzel Washington as Malcolm X. Washington asked Jeffrey Al-Muhammad to assist him in his preparation for the starring role, because Al-Muhammad knew a great deal about Malcolm X and Islam. Al-Muhammad joined Washington on the movie set. The movie was filmed in the New York metropolitan area and Egypt. Al-Muhammad presented evidence that his involvement in making the movie was very extensive. He reviewed the shooting script for Spike Lee and Denzel Washington and suggested extensive script revisions. Some of his script revisions were included in the released version of the film. Others were filmed but not included in the released version. Most of the revisions Al-Muhammad made were to ensure the religious and historical accuracy and authenticity of scenes depicting Malcolm X's religious conversion and pilgrimage to Mecca. He felt he was a co-author and sued for a copyright declaration of co-ownership. But here is the rule and holding as adopted. The statutory language establishes that for a work to be a joint work, there must be 1. A copyrightable work, 2. 2 or more authors, and 3. The authors must intend their contributions be merged into inseparable or interdependent parts of a unitary whole. A joint work in this circuit requires each author to make an independently copyrightable contribution to the disputed work. And so the Ninth Circuit held that it is also undisputed that Al-Muhammad made substantial and valuable contributions to the movie, including technical help, such as speaking Arabic to the persons in charge of the mosque in Egypt, scholarly and creative help, such as teaching the actors how to pray properly as Muslims, and script changes to add verisimilitude to the religious aspects of the movie. Speaking Arabic to persons in charge of the mosque, however, does not result in a copyrightable contribution to the motion picture. We hold that authorship is required under the statutory definition of a joint work, and that authorship is not the same thing as making a valuable and copyrightable contribution. We recognize that a contributor of an expression may be deemed to be the author of that expression for purposes of determining whether it is independently copyrightable. It is striking in Malcolm X how much the person who controlled the hue of the lighting contributed, yet no one would use the word author to denote that individual's relationship to the movie. A creative contribution does not suffice to establish authorship of the movie. Intent to co-author is intent to be co-authors, in fact. What Al-Muhammad's evidence showed, and all it showed, was that, subject to Spike Lee's authority to accept them, he made very valuable contributions to the movie. That is not enough for co-authorship of a joint work. One cannot intend to merge stuff alone. There must also be an intent by each to be co-authors together. Let's listen in on our interview to discuss this and then look at some reform proposals.
Let's go to another example you give in the book, and this is the mutual intent rule, and you can explain it probably really quick for our audience. But you talk about the mutual intent rule and how this rule can ultimately cut against women and minorities a lot. But the fundamental question to you I have for you is sort of the other side of it, and that is, why is that rule somehow not neutral or unfair, and why isn't it just sort of a bland rule? And if it's not a bland rule and it really is working in a way that's racist or sexist, is there a reform that we can do to this mutual intent rule in copyright?
Yeah, so the mutual intent rule is the subject of one of the chapters of the book. And to kind of give it simply, courts do not like creating situations where they recognize more than one author, because when they do, that means the copyright is split between those authors. So courts have developed this doctrine saying that you can only be a joint author with someone if each of the joint authors mutually intends to be a joint author with the other. Okay. In practice, what this rule means is that it means people who are relatively powerful, they never jointly intend to be joint authors with people who are not powerful. And so joint authorship ends up becoming a referendum on who has power. So I'll give you an example. There was a very famous musical on Broadway called Rent, and it was subject of a recent movie. Jonathan Larson is known popularly as the author of Rent, and he kind of died tragically just before the first dress rehearsal of Rent. It ended up becoming a big hit. But there was another woman, a dramaturge named Lynn Thompson, who actually wrote significant parts of Rent. Well, at the end of the day, she sued to be given co-authorship credit, not sole authorship, co-authorship. And the court acknowledged that she had written significant parts of the entire story. And despite all that, the court said, you know what? Sorry, you're not a joint author, because Jonathan Larson never intended to be a joint author with you. He didn't see you as his equal. And therefore, there is no joint authorship. And time again, courts have rejected joint authorship claims literally by people who are in lower bargaining positions, because of course someone with a higher bargaining position, whether it's in the music industry, the movie industry, the publishing industry, is never going to be a joint author or intend to be a joint author with someone else. So it really, instead of acknowledging creative contribution, this referendum standard on mutual intent is more about who has more power, who has more leverage, rather than how much did you contribute to the work. And to answer your question about, well, why does this impact race and gender or even class? Well, the answer is simple. People with lesser leverage in society tend to be poorer. People with lesser leverage in society tend to be minorities or women. And there's also an entire body of literature, especially in light of that Lynn Thompson case, that also talks about feminine versus masculine modalities of creativity. And much of this might be socialized differences, but nevertheless, those socialized differences are important, where the feminine modalities of creativity may be more cooperative, maybe less credit oriented. They may be less about who intends to be a co-author, who intends to be the big shot. But at the end of the day, the reigning standard on authorship kind of adopts a more masculine view and therefore systematically disadvantages feminine modes of creativity, but also more broadly, and also, by the way, modes of creativity in other cultures that are less centered on having a singular author, which often ends up effectively being a modality that might favor someone who is whiter or more male. And so that's why it often falls on socioeconomic, gender, and race lines. And as a result, we end up basically not giving authorship credit sometimes to some of the people who have the most creative inputs in work. And I think that impoverishes our copyright system because it means those people are not getting recognized. They're not getting resources allocated to them going forward because of their significant contributions to progress in the arts. And so not only are we getting harmed from an egalitarian point of view, but our copyright system isn't maximizing progress in the arts as a result.
So perhaps the shift needs to be, instead of a referendum on intent, when we all recognize that the winner of the referendum is always going to be the more powerful person, we should be looking more at the substance of who contributed what.
Would the substance of contribution, yeah. I mean, and frankly, look, intent is in the Copyright Act, but intent could be interpreted as simply the intent to take my part and put it with yours. That's very different than an intent to be a co-author, because intent to be co-author suggests I'm viewing you as an equal. Yes. And courts have taken that interpretation of intent. So yeah, I think a better rule would be viewing intent as simply I'm contributing my part, you're contributing your part, and then have we both contributed substantively?
Yeah, in other words, did we intend to create a play called Rent?
Correct.
Is the real question, yes.
As opposed to did we intend to be co-authors with one another? Because that answer every single time is going to be, Taylor Swift, if she writes a song with someone who is a no-name, isn't going to intend to be a co-author with that person. Neither is Beyonce, neither is Lady Gaga, right? It ends up, privileging might over right.
So this brings us to consent in authorship and how authorship vests in one who fixes the work. And this brings us back to a case John spoke about in the interview. This is the case of non-consensual sexual recording by someone of ESPN's Erin Andrews nude in her hotel room. As described by the Secret Life book, Erin Andrews was a well-known sports reporter working for ESPN traveling to Tennessee to cover a football game. Michael David Barrett, an insurance salesman, had grown increasingly obsessed with Andrews and, after determining her travel plans, stalked her to the Nashville Marriott where, after learning her room number, managed to cajole the front desk into giving him the room next door to her. Once in the adjacent room, he sawed through the door between her room and his to create a peephole and proceeded to record her naked in a video that he then shared with the world a few months later. The perpetrator owned the copyright to the video as he took it, even though she never gave consent and was the subject of it, given copyright law precepts. As a result, Andrews had to secure a judgment and forced assignment transfer of the copyright to herself, of the very video he illegally took of her so that she then could have standing to get social media sites to take it down. Remember our interview talked about the slave photograph case. Let's now turn to it. Here, Harvard owned old photographs of former slaves that it was exploiting financially by licensing them. One of the victim slaves' descendants sued to stop the exploitation. Her claim was that the photos were taken without consent, and her lawsuit was dismissed. The descendant cannot have property rights in a photo because the photo copyright interest belonged to the photographer originally. From a copyright analysis, the slave was not part of the authorship. Harvard claimed copyright due to its publication work on the photo to avoid public domain. Now, Harvard later agreed to donate the photo to the International African American Museum as the case ended. But there you have the copyright situation of the slave photograph not being able to control the copyright because the slave was not the photographer. How do we fix this? Back to our interview to think about some copyright fixes here.
So I guess that would be an example where your proposed rule would, in essence, we could protect victims of revenge porn by holding that either all sexually explicit videos, the copyright belongs to the performer, or if a video is taken without consent, the person who took the video can't even get a copyright, and it has to, by default, fall to the victim so that they can issue takedowns. Would that be a working rule?
Yeah, I think the latter would be the proposal is if a work is created unlawfully, the fixer who was engaged in the unlawful action shouldn't get the copyright. And maybe that goes to the Harvard University case as well, because in essence, this man was held in bondage and forced to sit for these photos. You can see the photos online. They're really tragic, and he's naked, and guarantee you he didn't want to be photographed, and he certainly didn't want to be photographed naked under those circumstances. So there's a real question as to why the fixer should have gotten the copyright in the first place.
Now let's turn to derivative works, and our case involving Hitler invoking the jurisdiction of American courts. As you will recall, the exclusive rights include the right to make adaptations or derivatives. A derivative work is a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. A work consisting of editorial revisions, annotations, elaborations, or other modifications which, as a whole, represent an original work of authorship is a derivative work. Let's listen to our interview again to set the stage for this case.
All right. The most unbelievable story I thought in your book was this case of Hitler getting an injunction in America against a future American senator. So tell us this story.
This was a wild story that I uncovered, and I'm shocked it's not more well known, but hopefully it will be. The story begins with a young man who goes to Germany during a junior year abroad. He was a student at Stanford, and he's in Germany. He's there in the early 30s, and actually gets to not directly meet, but be in the same room as Adolf Hitler, sees the people around him, and frankly starts being alarmed at the direction that Germany is going and with Hitler's views. When he comes back to the United States, he doesn't think much of it, but he while staying in Germany, he learned German fluently. And one day he's at the Macy's bookstore. Now Macy's is of course the big department store. They used to sell books, and he sees this big display, and it's a huge display selling the book of Adolf Hitler, this dictator he met in Germany. And again, this is in the 30s. Quite sadly, there was a rather large popular Nazi movement in the United States. Well, he picks up the book, it's Mein Kampf, and he starts reading it. And he realizes this isn't the version he read in Germany. In fact, it's been very carefully edited so that it would appeal more to American audiences, and some of the nastier bits have been taken out. This individual turns out to be Alan Cranston. He is a future United States Senator. He served as the United States Senator for the state of California, I believe, for a couple of decades. Anyway, he, in combination with a friend, decides that he's got to do something about this because Americans should not be getting a deceptive idea of what Hitler is all about. They need to know what's really in Mein Kampf. And because he has German language skills, he actually writes his own translation of Mein Kampf and puts it together and starts selling it at no profit. Really, the sales are all dedicated to anti-fascist organizations that are fighting the Nazis. Well, sure enough, he gets subpoenaed, he gets served in court. None other than Adolf Hitler and his publishing company, Houghton Mifflin, decide to sue him for copyright infringement for creating an unauthorized derivative version of Mein Kampf. And because of the derivative rights doctrine and the exclusive monopoly it gave to Adolf Hitler and Houghton Mifflin, they were able to get an injunction. So Hitler enjoined the publication of an alternate version of Mein Kampf that was actually more true to his original version. And our US court system helped him enforce that injunction. The I would argue more accurate versions of Mein Kampf were eliminated from the marketplace. And I'm not saying this caused World War II, this changed things, but it had a marginal impact because Americans, there were a large number of Americans for many years supportive of Hitler. There were large Nazi gatherings at Madison Square Gardens in the 1930s, photos of which are rather haunting. And all of this stemmed from the derivative rights doctrine and sort of uncritical view of the derivative rights doctrine and the way it can allow dominant narratives to basically go unrebuked, unchallenged. Through the prism of copyright law. And so I use this kind of terrifying example to suggest how big the stakes can be with respect to copyright. It may seem to be its own little corner of the universe, but in fact, it can impact the ability to criticize governments, criticize companies, and challenge dominant norms, tropes, and other ideologies. In a way that's quite profound and important in terms of robust political.
So now we get to Hitler's copyrights in American federal courts. You heard the facts already, so I won't repeat them. Suffice it to say, Cranston created his own derivative version in English, a Reader's Digest style abridgment version that was shorter and covered all of Hitler's original expressions. It sold for 10 cents to the original at $3. And so Hitler's publisher sued for copyright infringement. The claim was that this translation was a derivative work, and thus unauthorized by Hitler as a violation of his exclusive right to control derivatives. This is the defense's argument. This edition of Mein Kampf contains every important point, every important idea Hitler presented, every important sentence he wrote. Hitler's inconsistencies, self-contradictions, extremities, even his erratic language, all these are retained here. But we have eliminated his long-winded digressions and cut out much of the endless repetition which he himself explains is necessary in order indelibly to impress an idea upon the mind of everyone exposed to his propaganda. On an injunction motion, the defendant's main contention was that its edition is not sold in competition with plaintiff's book and that irreparable harm will come to the defendant by reason of a temporary injunction at this time. Therefore, the court enjoined the book. It said, quote, "The average person interested in world events, interested in Hitler to the extent of wondering what kind of a man he might be, interested in reading about current events in which Hitler has been taking an active part, for the purpose, perhaps, out of curiosity, perhaps out of desire to increase his knowledge, desiring to read Mein Kampf by Adolf Hitler in approaching a newsstand, seeing the two side by side, naturally would, under those circumstances, pick out the edition which costs 10 cents and which, on its face, purports to be Mein Kampf. I would naturally pick this one out because, after all, the average American buying Mein Kampf would not buy it for an addition to his library, nor because of its literary merit, but activated and motivated by an interest in current affairs and world events. I can see where this edition of defendants would be more competition than a book which cost the same amount as plaintiff's book. As to the irreparable harm coming to the defendant by reason of the issuing of this temporary injunction, it is also proper to consider the harm coming to the plaintiff. So the injunction issued. No discussion of fair use. Defendant had to destroy 500,000 unsold copies. It was a derivative work and an infringement. Back to our interview, to get back to gender and race issues and a counter view.
Now, let's take the other side of this, because one of the thoughts I had is that in the last 30-odd years, other than the corporate computer software area, I think the Supreme Court's only taken a couple of fair use cases. And in one, it protected the young black rap band the Two Live Crew when they were using some of Roy Orbison's music and his powerful record label. And so, the rap band won. And the other one was a more recent one where a female photographer took on the Andy Warhol estate, which is a powerful corporate estate, obviously, controlling his works. And she won too. Now, is there anything we can see in those cases that would indicate that no, minorities and women are being protected? Are they just anecdotal? How do you see that fitting into your thesis?
Yeah, I mean, look, there are certainly cases, not every case is going to, it's not going to be the racial minority or the woman or the poor person that loses. And those are two good counterexamples. But I would say this, First, in terms of those counterexamples, the Goldsmith case that you referenced, right? There were two pieces of IP in that case that we know of that the court discussed. Number one was the original photograph by Lynn Goldsmith, and number two were the prints that Andy Warhol did based on that original photograph. But what's really interesting is completely missing from that conversation was the third person, the third holder of intellectual property, without whom neither of those two pieces of intellectual property would have existed. And that was one Prince Rogers Nelson, an African-American man who literally got nothing. And the question is, are those works, do they owe their creativity to Lynn Goldsmith or Andy Warhol, or is there a substantial amount of the creativity that was brought to bear in those works from Prince? And why is he completely silenced from the entire dialogue? This goes to the subject issue, right? And then I would also kind of give a counterexample to some of the jurisprudence. This is kind of one of the more troubling examples on close questions where you have courts dealing with new technologies and things like that. You know, there has been an unfortunate seeming valence in terms of how the courts have approached these issues on sort of race, gender, and socioeconomic lines. And the example would be hip hop sampling. I alluded earlier, I said, by and large, courts have said that if you want to sample, you need to get a license. What's really interesting is there are two very prominent examples, counterexamples to that, where the courts found that when the defendant didn't get a license, it was okay. And courts invoked something called the de minimis use rule. They said, well, it's not that big a deal, therefore you don't have liability. Those two cases involve, number one, the Beastie Boys, a white hip hop group, and number two, Madonna, a white singer. Yet, when African-American artists were hit with sampling suits, in fact, the very first sampling case was involving an African-American artist named Biz Markie in a case called Grand Upright. The court not only gave him, read him the Riot Act and imposed massive liability, the court also quoted the Ten Commandments, said, "Thou shalt not steal," and basically said he was akin to a thief, and referred him to the U.S. District Attorney's Office for prosecution for engaging in the act of sampling. Something that certainly didn't happen to Madonna or to the Beastie Boys. And then in the other case that created a very bright line rule in one of the circuits about you shall never sample without a license, and the court basically said, get a license or do not sample, period. No de minimis use excuse. It was a case involving NWA, the African-American hip hop artists out of South Central LA, who were accused of infringing, not licensing a sample. So, there have been some troubling developments on those fronts.
I want to thank you for your time, John. I mean, brilliant book. It's so well written, acute intellect. And the last question I guess I have is maybe you could tell us the most shocking thing that you came across in creating this amazing book of yours. And also, where in copyright are you turning your intellect to next for your next book?
The most shocking one I came across, I mean, the Hitler one was pretty shocking, but I've already given that example. The Bambi was pretty shocking, but I'll give one that's sort of off the radar, doesn't involve anybody famous. In my book, I have a section about the use of takedown notices to get materials taken offline, and how individuals are drumming up copyright claims for materials when really they don't care about enforcing their copyright. They just want to get material they don't like taken offline. Well, there was this incident about this involving this married couple. They were in a terrible divorce. Okay. And the divorce was going very badly, and very tragically, the husband committed suicide. Okay. And in his last act, he wrote a suicide letter and put it up on a blog. Well, what happened? His wife didn't like the content of the suicide blog, and it was embarrassing to her. Because they were still married, the divorce hadn't gone through, she inherited his copyright. She used his copyright to systematically take down his suicide letter, wherein he explained all the ways in which she had led him to suicide. So a pretty profound, crazy, terrible example of use of copyright to censor basic speech. It's far from the worst example, but it's a little bit of a shocking, terrible fact pattern. So that's my.
That interview was fascinating to examine two specific areas of copyright law beyond our general overview we did. We looked at the intent rule for co-authorship and the author definition rule for ownership. We explored how cases can play out where these rules severely disadvantage women subjected to revenge porn or outright illegal recording. And we discussed some ideas around copyright reform to adjust the concept of ownership when there is no consent and illegality afoot. And in the original vesting concept, we looked at the fascinating slave photo case, the Google Garcia litigation, and saw how vesting of rights in the one behind the lens, without consideration of creative efforts and with a strict fixation on specific intent to be co-authors, disadvantages many. And along the way, we also looked at the Hitler case to explore derivative works rights and the power that can yield to stop translations without any inquiry into fair use. So is copyright racist or sexist? We posed the counter question that the Supreme Court has only taken 2 creative arts fair use cases in almost 30 years, and each time sided with the less powerful minority or women. And we saw the author's answer to that. You decide for yourself if this is a systemic race and gender issue, or just an issue of power differences between corporate America and the rest of society, but either way, the issues raised are serious and raise important questions to ponder for copyright reform. Thank you for watching this Curious Lawyer interview series. As always, reach out with any questions.